Okay, good afternoon, good afternoon. चलिए तो लेक्चर नंबर 11th we can start now. Everyone is here now. Okay. Uh, See, today we are basically we will study the last two topic of part A of the syllabus, right? That is your administrative law. The constitutional law obviously we have completed, right? So administrative law I will be talking about today, right? And now in administrative law, the last three topic actually which was left is basically topic 13, 14 and 15, right? So I will be discussing these three topic today, right? And I will try to explain subtopics as the lecture usually I take, that I will explain the subtopics and certain important case laws or concept that is related to it. Okay, so that also I will try to handle it. Okay. So let us start with the today's topic. See, if we read the topic, it simply suggests that separation of power and constitutional governance. Okay, so there are two distinct topics that is clubbed together, right? Separation of power and constitutional governance, right? So we will go into detail what is the meaning of these two. There is something called rule of law which is not given here, but there have been questions on rule of law as well. Okay, so constitutional governance has to be related with the rule of law. Okay, so that also we will cover. Then judicial review of administrative actions, there are various ground of it, right? So you have to study those grounds. Okay, and specifically the questions are there in the case of judicial review with related to the policy of the government, right? If the government forms a policy, whether that may amount to administrative action, and suppose the government changes, so can that policy be changed? Okay, so that is the judicial review of the administrative action. There are multiple doctrine, actually 2-3 doctrine related to it, right? You must have studied like doctrine of legitimate expectation, right? Similarly, we have doctrine of proportionality, witness-very principle. Okay, so all those things we will talk about it. Then we have very simple topic, ombudsman, lokayukt and lokpal, right? Now these three topics are usually very simple in nature, meaning the number of question asked in these topics are very less. Okay, usually one question, that too after 2-3 years. Okay, not regularly. Okay, so these are the three topics that we will be discussing. What are the subtopic that has to be studied in detail. Okay, so let us start. See, first you have to understand the concept of, you have to study the concept of separation of power doctrine, right? Simple concept of separation of power doctrine, right? So what is the meaning of separation of power, right? So you must be knowing there are three organs of the government, right? And there are three specific doctrine with related to separation of power, so you have to study that, right? It should be no one person should be part of both, right? And power should be developed into, divided into three groups. Okay, so the basic the classical concept of the separation of power doctrine that you have to study. Thereafter you have to talk about how this doctrine is dilatory doctrine. Dilatory doctrine meaning it is not very fixed, very variable in nature, right? So no constitutional law in the world or no constitution in the world can claim that my doctrine, this separation of power doctrine is totally ingrained in our constitution, right? And nothing have been nothing have been digressed from. Okay, so in absolute rigidity you cannot find separation of power doctrine anywhere in the world. Okay, so obviously that point we will cover, right? We will try to understand that why it is so, and there have been question on that separation of power doctrine with reference to that this separation of power doctrine affects constitutional governance. Okay, so that is what I mean by it is a dilatory doctrine, right? It means it takes multiple form and shapes depending upon the type of constitution you have, right? Depending upon the country you have. Okay, depending upon the historical experience that as a country you have, right? So there are multiple theories, it has multiple dilatory concept related to separation of power doctrine. So it is not a rigid concept. Okay, so that is the primary understanding of this separation of power doctrine. Okay, so that thing you should keep in mind. Then you will come to the second subtopic of that is the constitutional perspective of the doctrine, right? So in our constitution you have to pinpoint basically that which particular article indicates separation of power doctrine, right? If top of my head, if I can think of, there are two articles that specifically pinpoint the separation of power doctrine, right? Like the judiciary shall not inquire into the working of the parliament, right? So that is the line, right? So that is separation of power. Similarly, judiciary shall not inquire the advice given by the council of minister to the president. Okay, so that is again the separation of power, right? However, with the various judgments, right, this separation of power doctrine have been watered down. It is not in a strict sense right now applicable to our constitution, but still, right, separation of power doctrine in that sense has to be understood, right? So the constitutional perspective, right? So Indian constitutional perspective has to be understood, right? There have been multiple time question that our constitution do not recognize separation of power doctrine in its absolute rigidity? Comment. Very simple question, right? So what you have to do, you have to cite the constitutional provision related to separation of power doctrine, and then you have to come up with the different case law which have diluted this separation of power doctrine. Understood, right? Like the principle of judicial review of the state, of the legislature is basically one of the dilution of the separation of power doctrine. Okay, so you have to understand that constitutional perspective in a very, very great, detail and length. That is very important actually. Then you will talk about constitutional governance and separation of power doctrine. Okay, that is a specific topic, say constitutional governance and separation of power, right? So these two, even they are not clearly visible in our topic, still the question have been there. Okay, so that is why reading subtopics, right, understanding what are the subtopics related to that main topic is very, very important, right? That will help you to prepare a lot. Okay, now how do you make a relationship between them, right? So you basically say that separation of power doctrine ultimately aims at what? Creating a constitutional governance. How? We want that power should not be concentrated, right? So the very purpose of separation of power doctrine was that power should be divided into three co-equal parts. Okay, so that we don't have a dictatorship, right? So any democratic constitution, separation of power doctrine basically brings democratic transition, or cements democratic structure of that particular country. Without separation of power doctrine, the democratic structure cannot stand up. Okay, in fact, not having separation of power is something which is an example of a dictatorship. Okay, and then you talk about that how it you find the connection, right, that how it helps in the constitutional governance. Okay, and the philosophical point, how it helps, the first important point, it helps that it keeps check and balances to each and every one, right? Each separate part of the government keeps check and balances on other one, right? And it also helps the tendency of centralizing, not having a tendency of centralizing. Okay, so that is also a very important aspect, right? So two important interrelation is there between the separation of power doctrine and constitutional governance, right? Now these both has to be studied with the concept of rule of law. This rule of law has not been given in our syllabus at all, right? But still it is very much part of the syllabus, right? So even if it is not provided, you should study rule of law, right? The basic dices concept of rule of law, right? And then the recent amendments, or you can say recent development in the rule of law, right? Like in the basic dices concept, judicial review is not a part of rule of law, right? But in our constitutional structure, through judgments, the court have totally ingrained the judicial review as a part of rule of law itself. Okay, so that is the development, or sort of unique perspective, or the recent perspective with regard to rule of law, right? This year there was also question, 2018 there was also question, right? So rule of law, lot of question comes. I have given certain questions, we will see that, right? So this rule of law has to be studied even if it is not in syllabus. Okay, then we will come to the second topic, right? So this first topic you have to study 3 subtopic in that. Okay, so remember that it do not seem, it is not as small as it seems. Now if you go to the second topic, judicial review of administrative action. Now, if you look at the judicial review of administrative action, basically it says 2 things, right? First, what are the ground of judicial review, right? And second, the various doctrine related to it. That is the 2 things you have to study, right? See, I have written here judicial review of administrative action grounds. Okay, but obviously multiple grounds, right? Non-application of mind, mechanical treatment, right? Malafide intention, right? Multiple grounds are there, right? There are 7-8 grounds, right? So that actually have non-application of mind, right? So there are multiple grounds attached to it, right? So for each and every ground, you remember at least 2 to 3 cases. Okay, so that will be more than sufficient. Okay, take any standard textbook and you will find the multiple grounds related to it. Okay, then policy decision of the government. A lot of question actually comes from this part, right? Because litigation also you will see a lot of question, a lot of cases basically comes through this itself, right? There was a BJP government, they promised something to Ambani, and later on the government changed, and that government changed the policy, right? Now the question is that administrative decision which was done later on, is that challenge to judicial review? Okay, because that is an administrative decision. Okay, now that is actually something quite much in debate, right? So court have developed multiple principles attached to it, right? So 3 principles is basically important. First is the doctrine of 2 principles: promissory estoppel, right, and legitimate expectation. They are actually similar in nature but not same. There are slight technical difference. For the purpose of UPSC, need not to understand that technical difference. Simply understanding doctrine of legitimate expectation, that I will discuss also. I have given a case also. Then proportionality principle. This proportionality principle is basically mainly applies in service law. Okay, basically especially in army or some other defense instruments, you will see that people are harshly treated if they disobey their superiors, right? They are practically the whole pension is struck off simply by a simple wrong. Okay, so the court have consistently applied this doctrine of proportionality and said that the purpose or the when the administrative authority take a decision, right, so the punishment awarded must be in the proportion with the wrong done, okay, by the delinquent employee, right? So you cannot do anything. Like in army, you must have seen there is a concept of button charge, right? In army act, right, there is some section, I don't remember that if nothing happens, simply the senior authority asks, give you that क्योंकि आपका शर्ट का बटन अच्छा नहीं था, okay, a button charge, right? So those sort of excessive discretion is given to the administrative authority, right? And that button charge, practically someone pensions can be struck off, right? So obviously that person have a relief, going to court, that it is violating the doctrine of proportionality. Okay, so that is something very important doctrine, right? So again, that will come under the judicial review of the administrative action part, right? So that is an important aspect, so do remember it. Now if we'll come to the ombudsman, I have not written here because it is simply asked, simply the philosophical aspect of it, right? Do not read the article wise provision of it, not at all, right? What is the purpose of ombudsman, right? So ombudsman is basically, these three are basically part of administrative structure for grievance machinery, as a grievance machinery. Okay, so lokayukta, lokpal, political grievance machinery, sort of, if you have a problem with the person who is occupy high office, political executive, right? And ombudsman is basically friend of the people, right? So before going to the court, right, there is one more authority between administrative and court, right? Those authorities are basically ombudsman. Okay, so that is something perspective that you should understand. You need not to go into detail into that, right? Do not read the literal provisions. Never there have been a question about literal provision, right? So only the philosophical aspect of it, right? What is exactly the nature and the extent of that particular, what is the purpose of that particular body? That's it. Okay, I have given some questions also. You will understand what type of question comes. Okay, right? So these three topic can be divided into these 7 to 8 subtopics. Okay, now let us go to and try to understand some of the important case laws and notes related to it. Okay, now when we talk about separation of power doctrine, the most important case actually you have to study is the Ram Javaya Kapoor, as well as in the case of judicial review of administrative action, right? So the first question itself arises, what do you mean by administrative action? Does the executive power of state anywhere, right, anything done in the pursuance of the executive power is an administrative is a administrative machinery, or is the administrative machinery at work, right? It is administrative action or not? So executive action, administrative action is same thing or not? Okay, that is actually the point, right? So the first question, whenever this case arises, the first question itself arises whether it is an executive power or administrative action. That's it. Okay, now Ram Javaya Kapoor, briefly, it is an important case in almost constitutional law, most important constitutional law. In fact, when we talked about union and state executive, this case also I discussed, right? So here also this case I will discuss, very important, right? This basically defines that executive power of a state is basically whatever that remains after stripping away of the judicial and legislative power, right? So it have been defined in a manner that it is something which is left when everything is gone. Okay, so that is the meaning of basically executive power, right? So executive power is something, a very interesting concept, right? Now once it is determined that it is an executive power, then anything done in the pursuance of that executive power, right, and while doing so, the executive authority have had some discretion attached to it, okay, then it becomes an administrative action. Okay, so administrative action meaning that if you are doing something in pursuance of executive power, in pursuance of delegated legislation, in pursuance of any normal law, right, and there is some degree of discretion attached to it, then only it is subject to judicial review. Okay, so if a person is doing something under law and there is no discretion, he have to do something under law, then that particular order cannot be reviewed as administrative action. That can only be reviewed as a writ, right, that it is violating fundamental right and other thing. Understood? So that is the technical difference between review of administrative action and review of executive action. Okay, so if executive action confers some sort of discretion, and in pursuance of that discretion, if something is done, that becomes an administrative action. Okay, see, the whole branch of administrative law is what? When you have certain discretion to the administrators, right? So if the administrator have no discretion, there is no concept of administrative action. It is basically what the executive is saying, I am doing it, right? So the ground only becomes writ. Okay, so if you have an administrative action, then the ground becomes writs as well as the principle laid down, judicial principle laid down by the courts. Okay, so that is better, that if something wrong have been done to you, and that is basically administrative action, right? So that is better. I mean, there is lot of ground to be challenging it, right? So if it is, you know, purely administrative action, then only it can be done. If it is purely executive action, then only one solution, that is writs, right? Nothing else. So that is something you should keep in mind, right? Now, this also case is important. Asif Ahmed Harmad versus, it is Ahmed, I suppose, it is wrongly written, versus State of Jammu and Kashmir. Legislature, executive and judiciary have to function within their own sphere demarcated under the constitution. No organ can usurp the function assigned to another. The functioning of democracy depends upon the strength and independence of each organ, right? So this case is important for constitutional governance topic. Okay, so if you will practically cite this case itself and write this particular paragraph, it will have a very good impact on your answer. Okay, so that will be also very interesting, right? So you will need not to study anything else actually. Okay, then this is a very interesting concept that I told you that I will discuss it, right? That is policy decision of the government whether they are liable to challenge. Okay, multiple times this question come, and I gave you example also, right? Okay, there is one government, and that government gives, you know, certain concession for a particular industry, right? Suppose Adani is given by the state of Gujarat certain concession, and after some time it happens that the new government comes up, right? And they says that no, this concession cease to exist. Okay, now the question is what can be done? Can that action be challenged as a review, as a administrative action subject to judicial review? Okay, now that is the question. Let us see. At common law, judicial review of administrative action was not concerned with monitoring political and policy decision making activities of government, but rather with protecting rights whose policy are implemented in an individual cases. Okay, so in common law that doesn't used to happen. Beside political decision making, elected executive officials also routinely act as an administrative capacity. When they do so, their decisions are of administrative nature and are not exercise of executive power of the function. Right? तो देखिए कितनी इंटरेस्टिंग बात है. ये कह रहा है कि if a legislature gives power to executive power to through a law, through a normal executive, and there is no discretion, then that is not an administrative action. But if the same law gives power to political executive, right? So our the current law assumes that, our current scenario assumes that whenever political executive have been given any type of executive power, then he is bound to influence by political questions, even if there is no discretion, right? So two type of executive we have. One is the the career executive and political executive, right? So when we have this career executive, there if normally law have been given to you, power have been given to you with no discretion, that is not an administrative action if he does something. ये बात समझ में आई सबको? Give me a yes, नहीं तो मैं फिर से explain करूँ, बड़ा important concept है. हाँ? Yes, no. अच्छा कुछ लोग कह रहे हैं no, नहीं समझ में आया. Okay. Let me repeat. ये थोड़ा टेक्निकल पॉइंट है. मैं ये कह रहा हूँ, बड़ा सिंपल सी बात है कि there are two type of political executive. One is the political, one is the career. Now suppose there is a law, and that law confers executive power. ठीक है? Now this executive power can be exercised without discretion, with discretion. यहाँ भी हो सकता है without discretion and with discretion. ठीक है? So in the case of political executive, both of them will become administrative action. But in the case of career executive, only which comes with discrimination, that will only become administrative action. Okay, right? So if a law confers executive power on political executive, so whether they have a discretion or not, that doesn't matter. If he takes any action, the Prime Minister is taking any action, right? In accordance to the law, no discretion, still it will become administrative law. Because, administrative action. Why? Because it is assumed that it will be politically motivated, right? But in the case of career executive, that will not happen. Understood that point? That is what actually I was saying, that when they do so, their decisions are of administrative nature, are not exercise of executive power or function. So even so, law provides it. Hardik, I think you are a law optional student. I will explain to you, not to worry, right? That is in whole class, right? I will explain to you. Okay, so that is one thing you should keep in mind, right? So I think now it is very much understood. So that is why I keep saying law is very precise subject, right? If you understand the basic concept, everything is clear, right? So it is not something very tough actually. Now let us come to doctrine of proportionality. Now this doctrine of proportionality is basically a very interesting concept here. Is why it is an interesting concept? Because it is something which is mostly used in, as I told you, in the service law, right? In the service law, administrative action, right? Pension nahi mila, pension zyada kaat diya government ne, right? So a lot of thing happens, right? Lord Green, this is basically the historical aspect from where this doctrine comes, right? So if there is any question related to this doctrine of proportionality, do write this paragraph, right? It's a very good paragraph. Lord Green said in this Wednesbury case, when a statute gave discretion to an administrator to take a decision, the scope of judicial review would remain limited. Okay, so he said that okay, it can remain limited. Now he, after quoting everything, he said that there are three main grounds on which the discretion can be challenged, right? Illegality, right? You have exercised and non-exercised your power. I mean, you have chosen to not to exercise the power you have been given, or the otherwise, right? You have exercised the power that you do not have. Okay. Procedural irregularity. Then once the procedure comes, principle of natural justice also comes into picture. And then irrationality, right? At the face of it, it seems to be irrational. Now, what is irrational? Which do not appeal, or a normal person will not think, will not come to the same conclusion as the authority have come to, right? So that is the meaning of irrationality. Okay, now that is a very subjective test, right? The background of the judge, everything matters there, right? In the actual court, right? If the judge is from good background and the person is of good background against whom this case have been filed, then obviously he will take a side of it, right? I mean, his personal mental element will also come into picture, and that is natural thing, right? That is natural thing. Okay, he opined that the proportionality was a future possibility. Okay, it means in future it may do some harm. Okay, so that is the meaning of proportionality actually, right? So in India also this is same thing is followed. Now there are multiple case law related to it, right? So if you remember even 1-2 case law, that will be more than sufficient. Okay, now this Wednesbury principle and proportionality is basically similar, but there is slight difference between them, right? Again, for UPSC purpose, you consider both of same. Okay, if the question comes from Wednesbury, you write proportionality, then that is also okay. And then you can make a passing mention that there is a fine distinction, right? But that's it. So that will be more than sufficient. Okay, so you need not to go into that much detail. Then doctrine of legitimate expectation. Now that is a very interesting doctrine actually, right? Let me teach you. See, it says, it basically means, right, in contract law we have a provision of promissory estoppel, right? That a person cannot be allowed to take benefit of his own wrong, right? So if a person promises you something, right, and tomorrow he goes away, I mean, he divert from his promise, then he cannot be allowed to take benefit out of it, that act. Now, if he goes away from the promise and he personally is harmed, then that is okay. But he cannot be, allowed to take benefit of that particular refusal. Okay, so that is the meaning of doctrine of legitimate expectation, right? That if action have been done by me with a promise by you, right, then later on you cannot back on your promise. If you back on, then if I am wronged, I can claim the compensation. Okay, that is the meaning of doctrine of promissory estoppel. Okay, this example iska agar le le, right? So a lot of time it happens that a government comes into power and says okay, you come and open factory in my state and I will give you 10 years of tax holiday. Now suppose that is there, right? Now some company comes and he basically opens it, right? Tomorrow the government changes it, says no tax holiday is there, right? Then those company can go and say no, this is the violation of doctrine of promissory estoppel, or the doctrine of legitimate expectation can be exercised there. Okay, so that is in brief, right? So let us read again. See, the doctrine of legitimate expectation is an outcome of synthesis between principle of administrative fairness and the rule of estoppel. I told you, rule of estoppel in the contract law. It is the latest recruit to a long list of concepts fashioned by court for the review of administrative action. Okay, now when there is a question that what are the unique thing or what are the recent development in the review of administrative action, so doctrine of legitimate expectation is one of them. Judicial review is also one of them, right? Sorry, one of the ground of judicial review is this. Okay, so that you should keep in mind. Now today it has become a source of substantive as well as the procedural rights. Okay, it means the doctrine of legitimate expectation can be substantial as well, right? So substantial, it means that the whole policy and some procedure of the policy have been changed, then also it can be exercised. Okay, so the whole policy need not to change, right? So that is an important aspect. In such cases, the court may not insist the administrative authority to act judicially, but it may still insist it to act fairly. Okay, so basically, it is, if you are acting judicially, by default you are acting fairly. The doctrine is based on the principle that the good administrator demands observance of reasonableness where it has adopted a particular practice for a long time, even in the absence of the provision of law. It means that the habit that you have been doing, so if someone thinks that you will continue to do with that habit, then that someone is not wrong. Okay, so there is a legitimate expectation from another party that what have you done, the same thing he can expect you continuing to be doing. Right? आप जो कर रहे थे उसके आधार पर अगर सामने वाले ने कुछ कर लिया है, right? If the next person has done something, क्योंकि you are behaving in this fashion, right? Then it is very legitimate for him to expect that I will continue to behave in that fashion. That is basically crux of this doctrine. Okay, it should adhere to such practice without depriving its citizen the benefit enjoyed or the privileges exercised. Okay, so that is one thing you should generally it extends to 1 year. So tax वाले केस में खासकर 1 साल तक कोर्ट ये मानती है, right? कि in the beginning of the financial year you will say that I will give you tax holiday, right? Then it is legitimate to expect from the other person, by the other person, that it will continue for 1 year, or at least that tax period. Okay, so that is the doctrine. Again, you need not to go into that much detail of case law. The question never comes. Okay, but obviously, if you practice, you will have to study those. Because the case demands it. Okay, so that will be more than sufficient for it. Okay, now let us see some of the previous question. Now these questions I have taken from 2013 to 19. Okay, so now I have not taken a lot of previous year. Okay, because the paper changed after 2013. Okay, see what do you understand by the term rule of law. So even if it is not in syllabus, you have to study rule of law. Keep that in mind. The basic element of Dicey's doctrine of rule of law, this 2019 question. Be you ever so high, the law is above you. Discuss with the help of decided cases. Right? Now it is pure rule of law question. It has nothing to do with constitutional governance, nothing to do with judicial review of administrative action. Pure rule of law question. Right? So even if generally they don't used to ask like that, right? But in 2019 they have asked it. Okay. So this rule of law is very, very interesting concept. Okay. And do read it, even if it is not there in syllabus. So I have told you earlier. Now let us go to the second question. The office of the Lokpal is not to adjudicate the purpose, but to provide regular machinery for investigating grievances against administration in a discreet and informal manner. Critically examine this, providing for proper justification for the office of Lokpal in India. Now the best answer of this will be, one Hindu article related to the nature of the office of Lokpal. No need to cite case laws. It is simply a philosophical aspect of it that I already told you. They never ask, literal ki section 14 kya hai, 15 kya, no, they don't ask at all. Just write a normal provision. Okay? तो इसमें क्या लिख सकते थे, right? To see the keywords here are not to adjudicate, right? So you will write the nature is not to adjudicate. You will focus one paragraph on that. Then machinery for investigating against administration in a discreet manner. So you will find out the provision which talks about discreet, right? If you read the whole Lokpal provision, that talks about if a complaint is there, the complaint has to be secret. And before recommending the administrative agency to investigate, the Lokpal will try to keep that whole proceeding secret, right? Because it has political implication, right? So that is the meaning of discreet, right? So that provision you can cite actually, right? Then informal manner, meaning कि all the things that have been done the provision that have been provided in the Lokpal Act always talks about they will regulate their own procedure. Right? So they are not so much focusing on the technicalities of the proceeding. Okay? So that provision of the Lokpal can be cited, right? So 3 elements of this statement, 3-4 provision of the Lokpal can be added to support these 4 elements. Perfect answer. Okay? So that is what actually this question entails. A very good question actually. This again was last year, 2019. Do you think that current trend in judicial activism in India are inconsistent with the principle of separation of power? Current trend is inconsistent with the principle of separation of power, which is considered to be one of the basic features of the constitution. So this is something latest or legal development, right? So can you cite any judicial activism which actually violated the separation of power doctrine? Yes, recent, contemporary, any case that you can think of. I can think of multiple obviously. Mayawati Murthy case. Have you heard of this? UP Mayawati have some Murthy, right? And the Supreme Court basically did not do anything with regard to that, right? Now that is something very interesting, that if you have a murti of 3,000 crore rupees, right? And there were multiple petitions that why this, and PSUs were forced to basically give money, right? Nothing happened, okay? But if Mayawati makes one, murti of Kasiram and Hathi, right? Then you say that it is the waste of public money, right? Is it not the waste of public money, and is it waste of public money, right? Now, keep political, feeling aside, right? You may hate Mayawati or you may hate Modi, that is a separate issue. But don't you think it is the violation? I mean, court have, sometimes very judicially active, sometimes not judicially active at all. Okay, so that is, yes, BCCI appointing, not BCCI, Supreme Court appointing RM Lodha as a, administrator of BCCI. Yes, you can. Alcohol ban, yes, you can say that was in domain of executive, and the Supreme Court did it. Okay, so yes, you can cite. So you have all the answers here. Okay, so that is a good thing. Then in Sujay case is okay. I don't think that is related to fundamental right. Obviously, there can be argument, but mostly actually these 3-4 that I. Similarly, do you think that the institution of Lokpal that was in 2018, as envisaged under the Lokpal and the Lokayukt Act, is efficacious enough to curb corruption in India? Again, philosophical question. That is why when I keep sending you articles, or this newsletter. Everyone got this newsletter or not? Tell me. Everyone got this newsletter that I sent, I think, on Saturday. I mean, someone sent, not me. Okay, good. And keep those newsletters saved up, right? Because before mains, if you have, that 20-30, for 1 year, suppose 24 emails, right? So that 24 emails, 50 emails, right? You should, before mains, you should at least read them once or twice. Okay, so that is very good actually. And especially, related to this live law, right? So all the live law article has to be saved, right? उसको PDF form में convert करके save कर लीजिए, because otherwise it becomes, paid version, right? तो बाद में आप उसे पढ़ ही नहीं सकते. I mean, you will have to pay, right? So you can convert it into PDF. That will be a more better exercise. Okay, if you can do it, obviously. Right, so you have to actually criticize this Lokayukt and Lokpal. Then, administrative power actions are not always conflict in rule of law principle discussed with illustration. Okay, so you have to cite the case of law where court had upheld the administrative law. That's it. 10 marker question, not a very tough one. Do you think that the current judicial activism in India is inconsistent with the... अच्छा ये 2 बार लिख दिया मैंने. Okay, it has been done 2 times. Okay. The Constitution of India mainly subscribes to a threefold division of governmental functions and not to the doctrine of separation of power and its absolute rigidity. Okay, so basically, again, this question remains, I think, similar to... Okay, this question was not there, but I have discussed in the beginning itself. The question basically demands that you cite the articles and say that, okay, Constitution of India do not, do not recognize the doctrine of this separation of power in absolute rigidity. See, basically, what is the relationship between this, separation of power and administrative law? Think. Let me explain here a bit, right? Very simply. See, what is administrative law? Administrator exercising discretion, right? So once discretion is there is a problem of that, justice cannot be done, then the administrative law comes in picture. Now when we have separation of power, right, it means that every function is totally separate from each other. Then the concept of discretion will not arise. Okay, so whenever we have a dilution in the separation of power, then only the administrative law comes in picture, right? So if the separation of power doctrine or separation of power doctrine is very rigidly followed in our constitution, then there will be no need of administrative law. So administrative law only comes into function when the executive starts to deliver justice in forms of administrative law. Executive starts to decide something which the judiciary has to decide. Understood? Okay, so that is the contrast between administrative law and separation of power, right? So if there is absolute rigidity, there will be no administrative law. If there is no rigidity, there will be discretion. It means that there will be administrative law, right? Meaning that one part might be performing the function of other part. Okay, so that is the unique you can say interconnection between the administrative law and separation of power. Okay, so please keep that in mind. Okay, so yes, so that ends the whole the discussion. Now let me check some of the copies that I have given. There are a lot of Hindu article. I don't remember actually the one of the Hindu article, but I'm giving some of the example, right? Obviously to the students who are my law optional, I will be supplying some articles, right? But generally you can find in Hindu, or if you have been continuing this this Telegram group, I will also send there also, right? So you can see that. Okay, now let us come to the questions. Now the number of submission have drastically decreased. Okay, I can see that number of submission have drastically decreased, right? I think only 3 people actually submitted, so I choose only 2 here. Same thing happens in class as well, right? In the first few weeks, people are very जोश में रहते हैं, lot of enthusiasm, and as things progress, right, the enthusiasm actually wanes up, right? So it is natural thing, right? It happens. The same thing happening with you all, right? इसलिए कहते हैं ना कि while preparing for UPSC, 80% are not actually the candidate. The only 20% are actually candidate, right? And all the coaching institution runs from the money of the rest 80%. Okay, 20% takes the full benefit of his money, his or her money, right? But 80% simply come and give money and go back, right? So that happens. That naturally happens, right? So that is not something unique actually. Okay, so let us start with this. The doctrine of excessive delegation. Acha. Is a judicially tailored principle. Doctrine of excessive legislation. I think the question structure was different. Acha, this is the question. Okay. Okay, so I have to talk about delegated legislation. Okay. We have taken something historical aspect also. Good. It should go in conclusion, okay? It should not be in the beginning. If given recent example, that should go in conclusion. No, you have already written a status before constitution meaning. I mean before the this enactment of the constitution you are talking about. It is too much, right? This historical aspect, make it shorter. थोड़ा आपने ऊपर mention कर दिया, that is sufficient, right? Here you can actually replace it with need. ठीक है? Again आप historical aspect की बात कर रहे हैं. At least heading here dictate कर रहा है, तो heading could be much better, right? Like judicially tailored principle, that should be a heading and this should start. Safeguard, okay. Central test, good. तो यहाँ पे लिखिए कि these all are basically decided by the courts. Okay, so there is no statute which have tailored which have defined the concept laid down in the Delhi judicial case, right? So focus more on that. You have written nicely that okay, these are the tests. Now who have invented these tests? Who have come up with these tests? So obviously judicial. So you cite okay, judiciary have come up with this test, right? And connect then that. Hence we can conclude that it is judicially tailored. Okay. Okay. Yes. You improve here. Okay. Improve here and focus how it is judicially tailored. ऊपर आपने बिल्कुल सही लिखा, बस connected that it is judicially tailored, right? Keyword क्या है? It is judicially tailored principle. तो उस point पे कम से कम 2-4 लाइन लिखना चाहिए. Okay, now let's come to the next question. This is also I think Durgesh one. Okay. So you have taken the view that it have been recognized. Okay, good. ये ठीक है. This part actually was missing in this particular paper, right? Contrasting between both. Yes. बस एक piece. Oh my God. बालक ये क्या है? One piece. तुमने डाउनलोड ठीक से नहीं किया है, पता क्या है? ओनली 1 पेज, राइट? राइट मोर लिखा होगा तुमने, लगता है एक ही पेज से भेजा है, इसलिए गलती से इतना याद है. ठीक है. ओके एवरीवन, सो दिस विल बी टुडेज क्वेश्चन भी तो देना है आप लोग को. इसमें से कौन सा क्वेश्चन लिखेंगे? आई थिंक ये लिखिए लास्ट वाला. राइट दिस. राइट, क्वेश्चन नंबर 7 यू प्लीज डू इट. ओके. ओके एवरीवन, नाउ इफ यू हैव एनी क्वेश्चन डू आस्क मी. Yes, Priyanka, go ahead.
Hello?
Please go ahead. I can hear.
Hello?
Yes, yes, we can hear you. Please go ahead.
Okay. Sir,
Hmm.
my question is sorry, sir. In last year question, there was one question like differentiate between federal constitution and federal government based on judicial pronouncements and which one does India follows. So what will be the answer for this one?
We will say that India follow federal constitution but not federal government. See, the difference between federal constitution and federal government is that federal government simply means that the power division with respect to executive is totally federal. But when we say federal constitution, it means that we are saying that power division between all three organs of the government. Right? So in India, the executive part is not federal at all. Okay, it is totally unitary in nature, at least semi-unitary in nature, right? Judiciary is totally unitary in nature,
Okay.
and legislature is, more to a federal in nature. So we can say that we have a federal constitution, but when we say government, then it is not a federal. Okay, and you can cite example like provision of 356, provision of 360, right? Provision of emergency. You can cite, 352 as well, 353 as well, related to that in the case of conflict between law or the executive, that the line given that executive power of the state shall not be exercised in derogation with the executive power of union. What does it suggest? That the executive power of state is inferior to the executive power of union. Okay, so we don't have a federal government, but we have a federal constitution.
Okay, sir.
Okay.
Thank you.
Or our college. I don't know which college you are from and what is your notes, so I cannot comment on. Yes, Mr. Suha Saul. Yes, please.
Good afternoon, sir.
Yes, good afternoon.
Yes, sir. So I have a doubt, sir. So now government they are handovering a lot of government sector to private. So
Government there.
can we apply? Yeah, like privatization.
Okay.
Privatization is happening right now. So
Hmm.
can we apply doctrine of legitimate expectation there?
Yes, but if government have announced कि, okay, I have taken this policy decision that 74% I am allowing in defense. Now, in pursuance of that decision, if some company comes and invests in India and later on government backs down it, then that company can claim doctrine of legitimate expectation. No doubt about it.
Okay, sir. Okay,
Okay.
thanks.
Yes, Mr. Aswin, go ahead.
Good afternoon, sir. Sometimes questions are asked which involves tussle between the executive and judiciary. So, sir, which side do we side? As in,
Executive.
can we criticize
Executive.
either of the
No, no.
sides?
Go through executive. I told you in the first lecture also that sometimes it happens that most of the time the questions are such a nature that somehow says कि, okay, executive is better rather than the judicial. Right? So
Yes.
side with the executive. This is UPSC paper, and you want to become the member of executive,
Yes.
right?
True, sir.
Yes.
Thank you, sir.
Okay. Okay, then I told you Mona itself, right? This will be again updated, right? It will be again updated, so no need to go through that, right? So you please let me again explain you, right? No need to read in detail. I told you Mona, it will be uploaded as well, right? So no need to worry about it. Okay, no need to worry about it. Okay, everyone. So let us wind it up.